matters before the jury comes in?
Your Honor, the defense and I have reached an agreement on defendants' we have no objection, they have no objection to the state's 253, which is a digital photograph. So this is the CO's screenshot.
Is that correct?
That's correct.
All right, they're admitted.
Thank you.
Do you have reply testimony?
No, sir.
All right. Mr. Have you decided who one representative from each side with no media present will accompany the court officials to the, for the jury view? Have you all decided who that one person will be?
Yes, sir, we have.
All right, who will be for the state?
Ryan Alfaro, my deputy.
And who will be for the defense?
Your Honor, that's Rob Purcell. He's one of our investigators.
All right. And of course, you're going as observers, not to have any discussion, contact, communications of any sort with the jury. So I'll bring them in, and we could do that, have them go while we're continuing to hear arguments, et cetera, further discussions at all. So the bailiffs and court officials who will be going to, going with the jury, I need to have them come, everyone come in to be sworn. Just the folks who are escorting, whoever they want, not the jury. All right.
It's going to take a few minutes to muster everyone that's going on the trip to a big number.
Well, the folks who are transporting are really not escorting, but I think the escorting or the court officials will include you in that. If you want to be included in that.
I just, doesn't matter. I can stand.
No, I think it's fine. Officer, what's his name? Sergeant, yeah. Yeah, you know. So the general rule is to swear everyone, give everyone an oath for everything, so it's not a problem. But how many other folks are coming this way? Okay. Well, we'll swear you all, and then we'll swear the 6 of them. All right, if you will raise your right hands and say aye, and then state your name. All right. Then you put your. Do you swear that you will keep the juror sworn of this jury during the time that you escort them to this property, and that you will return them to the jury room, and that while you are with them, you will allow no one to speak to them, including yourselves, and that you will keep them in your custody and bring them safely back to the court.
I did.
Very well. That's it. For the oath, I will swear the others. In the meantime, we'll have the jury come in and I'll inform them that what's going on.
Your Honor, do I need to rest again?
I think so. The state is the defense is rested. I've noted the defense's motion. I think you can rest as well, but I'll inform the jury. So, this Jewish script, so we have the oaths. Have Julie come in.
Jurors are all present, Your Honor.
All right, very well. Good morning.
Good morning.
Mr. Foreman,
Yes, sir.
how's the jury doing?
Phenomenal.
Oh, very good, very well. The defense has rested. Any reply by the state?
Your Honor, the state rests.
All right, ladies and gentlemen, the state has rested as well. That means you have heard all of the testimony in this case and you have received all of the evidence in the case. You will now be taken to view the scene of the alleged crime. And while you're on your way to and from the scene, and while at the scene, and we certainly know based on the testimony it encompasses multiple areas, if you will. But while you're on your way to the scene, while at the scene, do not discuss the case with anyone, including your fellow jurors. This is called a jury view. You cannot deliberate, you cannot discuss the case while there. You're going to observe to assist you, if it does, in just overall comprehension of things. And you're not to ask any questions of any lawyers who might be there, any court personnel who might be there, or ask each other anything while you're there. Except if you have any questions, I will not be there. If you have any questions, your clerk of court, Julie Armstrong, will be there. You can ask her directional type questions, and she'll communicate with me as to whether a response, if it's anything involving other than can we go now? Obviously, you can ask her that. We will have you go to the scene and we'll reconvene for closing arguments when you return. Please go back to the jury room and follow instructions to leave. It's a jury view, so there are no note-taking or anything of that nature. Notes are only taken in court. Any objection to the jury view procedure?
No, sir, Your Honor, I was just asked about whether the drivers need to be sworn.
Yeah, they're the next crew.
Okay.
Yes, ready for it, Mr. Savage? All right.
Thank you, Your Honor.
Oh, scripts. You sent it.
Right. Right there, please do.
All right. I thought they said there were going to be 6. I didn't think there'd be 6 drivers, but how are y'all doing? Good, good. Give me 1 second there. Oops. All right, you're going to take an oath to, if you'll raise your right hands and state your name. I.
I give a call, what's the punch?
All right. And you can, do you swear that you will transport the jury to the property and return them to the courthouse, and that while you're transporting them to the property, you will allow no one to speak with them or to them, including yourselves, and that you will keep them safely in your care and bring them back to us? Thank you. Very well. Thank you. All right, we'll take about 2 minutes and then we'll be ready to hear the defense's directed verdict motion, discuss anything further regarding jury charges at all. All right, Mr. Savage.
Thank you, Honor. May I please report?
Mr. McKean.
Yes, sir. The defense would request that the court direct a verdict of not guilty for Officer Slager. The evidence, even when viewed in light most favorable to the state, just does not substantiate the elements of the crime. As far as the elements of the crime of murder, there's been no evidence of malice. The items that the state pointed to that might indicate malice earlier have turned out to be things that Officer Slager did by procedure and by the book, that is the handcuffing of the body, and also rendering aid. He did call for EMS. So we think there's been no indicia of malice that's a required element of murder. We don't think he should be found guilty of murder. As to voluntary manslaughter, there once again is no evidence of heat of passion that resulted in a desire to do an uncontrollable impulse to do violence. The actions taken by Officer Slager were in self-defense. They weren't meant to do violence, but meant for self-protection. And we think that there is no evidence in the record that indicates that there was any uncontrollable impulse. And further, the state would, the defense would renew all our previous objections that we've made during this proceeding, and we would urge the court to direct a verdict of not guilty.
All right, says the state.
Thank you, Your Honor. I'll be brief and just point back to our arguments that we had at the arresting of the state's case. Again, we point to the act itself of shooting a person 8 times in the back as the most poignant and relevant evidence of malice. As well, we have the manipulation of the scene. Just whether or not that was done out of procedure or out of some more nefarious motive is an issue for the jury. As to voluntary manslaughter, I think the case of the arrest of the state's case was strong. We have always had this incident portrayed by the defense and through the testimony of witnesses as a reaction to the provocation of the deceased Mr. Scott. But if anything, the argument for voluntary manslaughter became much stronger through the defense's case. And I point to the testimony of Dr. Morgan, who characterized this entire event as a unreflective reaction to a provocation, a high level of stress. We think, and again, when directly asked, so there's a legal term for all of this. He said yes, and I said that term is heat of passion, and I believe the answer is yes. So I think his testimony, as well as many, many others, as outlined in our brief that we filed, certainly supports the charge of voluntary manslaughter. We think the direct verdict on both charges should be denied.
How about the issue of malice?
The issue of malice, it's evidenced by the act itself. The 8 shots to the back of a person fleeing is in of itself, in light most favorable to the state, evidence of malice.
We have 2 types. It's malice expressed and implied. Which one is that?
Well, certainly that would be implied. I think it would be incredibly strong evidence of malice, but certainly didn't involve any words. But that's not a requirement, as Your Honor points out.
So the law that says malice may be inferred from conduct showing a total disregard for human life. Would that be what you're currently arguing?
Yes, Your Honor. As evidence in the video, as we argued in the rest of the state's case.
All right. Response, if any, Mr. McCune.
And Your Honor, we would just point out to the inference of malice from the shots, with a number of shots. The shots stopped immediately when the threat was suppressed. There was, I think, adequate reason to fire the first shot, and there was adequate reason to continue firing. To infer malice or forethought from things that happened after the first shot, I think, is to misconstrue the malice. Now, there can be inference of malice that arises afterwards. We just don't think that's it, and we would request a corrected verdict of not guilty.
I think it's all a jury issue on whether clearly there was no express malice, but whether malice can be inferred from the circumstances surrounding the shooting. That would be an issue for the jury. With regard to the lesser included offense of voluntary manslaughter, the difference between murder and manslaughter is that murder is the killing of another person with malice. Voluntary manslaughter is the killing without malice. So if malice is not present and the jury were to not infer malice based on the circumstances of the shooting, but conclude that nevertheless it was an unlawful killing or killing without malice, an unlawful killing without malice, then they could consider whether the defendant is guilty of voluntary manslaughter. The state has submitted a well-written memo on this issue of manslaughter, and the court is duty-bound to charge the law as introduced in the trial through the facts and testimony. And based on the law of this state regarding the killing, unlawful killing of another in a sudden heat of passion based on sufficient legal provocation being the basic test for manslaughter, I find that there is sufficient evidence to charge the jury on this issue as reflected in the state's memo. So I deny the motion for directed verdict. With regard to we have had the proposed charges emailed to you all. The one issue that we were, Mr. Shealy and others were arguing last night on the Garner v. Tennessee and these various federal cases, common law, etc. I've boiled all that down into this arrest by police officer charge. What says the state?
Judge, we're very satisfied with the charges as proposed by the court. We think that certainly that encompasses the spirit of Tennessee versus Garner, Graham versus Connor, if not all of its language that's exists in various forms out there, and it adequately covers the subject in a way that's elegantly to the point, and we're satisfied with what the court's doing.
All right, says the defense.
Thank you, Your Honor. The defense position, two things with respect to the deadly force and arrest charge the court has proposed, and specifically with regard to the court's self-defense charge. We are not going to go back into that this morning. We just reiterated we still object based on the memo we filed and the reasons we set forth last evening, and we'll stand on our position at this time on that. There are a couple other things, but they don't have to do with the charge.
All right. Well, I think State v. Cooney is really a good case to give us some instruction as to what to do in this situation. In State v. Cooney, that was a citizen arrest where the guy on the plumbing business, and his business had been burglarized, so he decided to stake out and be on the lookout for the burglar, and this guy appears, who they determined was the burglar, and who they determined had been committing the felony of burglarizing their business, and he took out running, and they killed him while he was running away. So the judge in that case decided, as a matter of law, that you can't shoot an unarmed person running away, even if you believe that that person had committed a felony. And they reversed that part of the case, stating that that Cooney was entitled to a charge on the rights of the citizen in making an arrest. And I think they have a few lines in there that helped me to craft this charge. in the case that the court said in order to invoke the defense of the justifiable killing and apprehending a fleeing felon, the appellant at a minimum must show he had certain information that a felony had been committed and he used reasonable means to effect the arrest. There was evidence presented that a appellant had certain information that a felony had been committed, and that the determination of the reasonableness of the force depends on the facts of the case, and it is a question for the jury. Unless there is no evidence to support a finding of reasonableness, and in that case, the trial judge found killing an unarmed fleeing suspect is per se unreasonable, and they held that it was reversible error to not charge the jury on the common law of citizens arrest and the use of reasonable force, since evidence placed appellant's reasonableness in apprehending Mr. Williams an issue. So back to the defense's common law argument yesterday, some of that pertains and applies in this instance. And the court must let the jury determine in this instance whether the force used in attempting to arrest Mr. Scott was reasonable. That's the essence of the case. And so the question, however, is whether or not if that is a charge, and the jury said if you find that the force used is reasonable, then you must find him not guilty. Then do you also get a self-defense charge, or is that a duplicate? Is that a double charge with the same thing? So I'll hear what y'all have to say about that. You get self-defense and arrest and reasonableness of arrest?
I believe so, Your Honor. I understand your point. It sounds sort of duplicate, but I certainly don't want this going up with us refusing a self-defense charge. I think that's kind of in play here too. So
I'm surprised. Well, I'm not surprised. I'll withdraw that comment.
okay.
Quite often, each side just wants a great charge that helps them, regardless to appellate consequences.
I think under the evidence presented, a self-defense charge.
All right. What says the defense?
We have nothing again other than what we presented last evening.
All right. Well, I'll charge both. All right. That answers that question. The defense had a lot of witnesses yesterday testifying concerning the good character and good reputation of the defendant, and the law is that the court must charge the jury where there is evidence of good character and reputation, and so that's included in the charge. Anything else about the charge?
Nothing to say.
Your Honor, just a brief advised by Mr. Slager that there may be some law after the defect that place a not guilty verdict of character alone, character evidence alone is sufficient, so we'd ask the court to consider that. I don't know if you can quite say it that way, but that's what that will consider.
So what I have here is the defendant has presented evidence of his good character, good reputation and character to show that it would be inconsistent with the defendant committing the crime. The weight you give to that testimony, like all other testimony in the case, is for you to decide in your good judgment. You may consider testimony of defendant's good character along with all other evidence in deciding whether or not the defendant is guilty or not guilty. Now, you want me to change that to say what?
Well, just the character alone is sufficient basis for the jury to acquit for them to find no malice and that kind of thing. That's all. The character alone is sufficient.
All right. So,
I just think that's an addition. That's not in lieu of.
it says the state.
Judge, I think there's some antiquated language that can be found in very old cases, but the more recent cases have spoken with approval of the type of charge that you've just given, which really boils it down to its essence, which is that, you know, you can consider good character and whether or not you find malice in the case, but I don't think that's a proper charge, that character alone. Good character is not an element of the charged crimes. And I think in some of those cases what they're referring to.
Well, is that, or would that represent the facts in this case, or you have some testimony of good deeds, some testimony of bad deeds, some good character testimony, some...
Yeah, and the state, I should note, it doesn't object at all to the charges given by the court on the good character, but it can be considered. We just think it's adequately covered in the charge as drafted by the court.
Well, the reason I posed the last question is that, is this a case where you have good character evidence alone, or is it a case where you have more balanced presentation of some good deeds, some bad deeds, some proper use of force, some improper use of force, some good taser use, some bad taser use, is the and giving the jury a charge on the law, should it be a balanced charge as opposed to one, in effect, not commenting on the facts, but intimating that we just simply have good character in this case, and not a more other evidence for the jury to consider. That's why I asked the last question.
And I think that's why your charge is drafted as good, is because it keeps it basic. The bottom line is it's kind of not fair, because we don't get to discuss bad character and evidence of bad character, because that runs afoul of how that's to be considered. So I think hands off bad character is the cleanest way to do it, not to run afoul of that law. But like Your Honor says, when you start expressly saying things about the good character and finding reasonable doubt based solely on that, one, that really is getting towing the line of jury nullification, saying that if you think someone's a good guy, you can find him not guilty just on that. I'm not sure that's a very modern, current approach to the law, but to get to your point, Your Honor, I think that's why the way you drafted it is perfect, because we can't talk about the bad character and bad character evidence as something to be considered, because that's disallowed under the law. So keeping it just as you have it, which is that you've heard some stuff about good character, you can consider that however you see fit, I think is the most easy to understand and most accurate way to express that concept to the jury. And that further stressing of that good character comes close to jury nullification, and it comes close to charging on the fact.
Anything else on this issue?
Mr. Savage would like to address the court.
Yes, sir.
Good morning, Judge.
Good morning.
Judge, I don't think the state is correct in their allegation, certainly under 404. One, the state could have, if they had, put up character evidence to rebut the good character evidence of the defendant. They chose not to do that for the reason it didn't happen. Under 404B, the state has said they did not have any prior bad acts that they would introduce, and they have not. The evidence that has been adduced is that Mr. Slager used his taser, but it was repeatedly characterized by numerous witnesses that the use of the taser was appropriate in each and every occasion. So there is no 404B. There was an opportunity for the state, it was the 404A1, and they did not do it. Therefore, we think that the evidence of good character alone in this case is sufficient to acquit the defendant of being charged.
All right. Anything further by the state?
No, Your Honor.
I think the issues that have been put in play through the testimony, whether through direct examination or cross-examination, of course, to a great extent, delved into cases that you typically would not expect to be brought into these proceedings, but nevertheless, we went beyond what was germane in this case to other cases. But I believe that as a result of the examination and the cross-examination, a balanced charge that doesn't intimate that the defendant's good character alone can be a basis for an acquittal should be charged, because the evidence does not solely indicate good character. The evidence raises other issues that the jury might consider. So this charge that does not concede anything with regard to character and representation, other than that some evidence has been presented and the jury can consider that, I think is adequate, and I'm going to charge what is the standard charge on this issue. And the jury may consider this as well as all of the testimony in the case. All right. What else?
Your Honor, Mr. McHugh had raised an issue he asked me to raise in the court again today. We talked about it briefly last night about closing argument. I don't think we're going to talk about that non-time.
Yes, sir. Let's talk about it.
Just about requiring the state to open in full and then allowing them to respond to anything we say, but not bringing in new material. We filed a motion on that, so that's before the court. So that's one of two things I have to bring up. That's
All right. Tell me about that requirement and why are you entitled to do this motion to have it granted?
I'm sorry.
Tell me why are you entitled to have this motion granted?
Well, we sat some authority in the motion, Your Honor. We think that it's basically just unfair for the state to bring out, and there's some cases decided in our motion, it's unfair for the state to bring out new material when they come up to respond to the jury. They can certainly respond to anything we fairly say, but we can't respond to that. That puts us in kind of a due process, kind of a basic kind of.
And typically the state opens on the law, and then the defense argues, and then the state comes and brings in their final plea, since they have the burden of proof, and they bring the full bear in the end. So what is that proceeding? The procedure, the state opens on the law and defense makes its argument, then the state responds in full. Is there a statute, law, or anything that supports that or disagrees with that?
We have some authority.
So tell me about it, because I'm listening and not reading.
It's on page 7 of our motion. We cited Bailey versus State from Delaware, Donnelly versus. I'm sorry. It's Bailey versus State. It's a Delaware case.
Oh, you're taking me to Delaware?
Yes.
Huh.
And Donnelly versus Christopher.
Where is that from?
It's the United States Supreme Court. But obviously the court has a lot of discretion on this. But if you're going to allow the state to respond in such a way and make comments that we have no way to respond to, especially in this case, we think that's unfair.
Well, the state gets the final argument.
We don't dispute that.
because the state has the burden of proof. If the defense presents no defense, then the defense gets the final argument, except, that's procedure, except for a death penalty case.
I understand that. It's required to open in full, but it's also notice of their argument.
So you're asking me to create some new law procedure or something in this case, or based on what they're doing in Delaware, or?
Your Honor, we just think that it preserves the burden of proof in this case beyond a reasonable doubt. Because while they get the right to propose a finding, because they got the burden, they should be able to kind of surprise us with new information. That's why we're asking to open in full. We're not asking to deny the right to respond, just to open in full. And then obviously they can respond to whatever we have to say.
But the whole notion that the state is supposed to open on the law, I mean, that's been traditional jurisprudence in our state, open on the law, then close on full. Is that statutory or just some of your common law, or what's that based on?
It's just based on some cases I've cited.
Based on cases?
We think that basically ensuring the state has the burden of proof here, that it's appropriate that they open fully on the law. We respond. We're not trying to get surprised.
I'm good with cases, but not cases from Delaware.
I understand.
We go there for chancery law. We go there for
I understand.
all the corporate stuff, but not for our criminal laws.
I understand that, Your Honor. We made our case, we filed our motion, and we think it just makes sense about the due process, about the burden of proof that it's fully upon the state, that in closing at the last minute, they don't kind of make any arguments that have never been made before that we never had a chance to respond to.
So in your first full paragraph, the current practice in South Carolina, criminal practice, seems to be that if the defendant introduces any evidence, the state has the right to the last argument, with the defendant being able to request that the state open on the law. But there is no statutory authority or rule governing this order of presentation. The current practice is based on common law. So yesterday you were fully into the common law,
That's right.
and now you're fully against the common law.
But the court would like to reverse that. We'll go back to yesterday to do it. But we'll take you up on that. We'll let them argue that way. You guys go back yesterday. I'll offer you that. So, but we do, as the court pointed out, there are some differences, and there's due process and there's the burden of proof. It's kind of undermined if you can bring up new stuff last minute before the jury.
All right. Let me hear what the state says about it, Dave.
Again, we addressed this yesterday, and the legislature has had an opportunity to address this issue. If they wanted to change the way we do business, they could have, they didn't. This has been the practice and tradition in our criminal courts. We have the burden of proof. We have to prove our case beyond a reasonable doubt, which is a very heavy burden, which is the reason that we should have last argument. I don't believe that this has cited anything that would mitigate away from doing things as we have done them, especially in light of the fact of how fresh this idea has been rejected by our legislature. So we'd ask that you keep with the practice and procedure in this state. While certainly this case has garnered much attention, this is simply a murder case, and there is nothing special about it when it comes to practice and procedure.
Which book, where was this erroneous publication of this rule?
It was not in a statute or rule book, it was in a bench book, I believe, that's published by the bar. Justin Kahn, who is a lawyer here in Charleston, who publishes this book every year, evidently had the rule as proposed, and that made it into the publication that was used, and that created a problem.
Well, he certainly has an excellent publication, which we all rely on in many instances, and unfortunately, I understand some judges in grabbing the book assumed that it was correct and the rule had been changed, and where it wasn't adopted by the legislature.
Correct.
So that Mr. Shealy, there's no authority for me to grant your request or to change the longstanding practice in the state with regard to the presentation of closing arguments. And I respectfully deny the motion. All right, what else?
Your Honor, the other thing that asked the court to consider, we have to file a motion on this, but I think it is established law, would ask that we don't intend to do it either. During closing argument, that neither side ask the jury to put themselves in the position of Mr. Slager or Mr. Scott. We think that's inappropriate, and I'm supposed to do that in general. I'm sorry, I do not have the case cites, but I do think there's authority that the jury is not supposed to actually put themselves in anybody's shoes in that respect.
Neither side intends to
Neither
do
side.
that. I mean, your side doesn't intend to do that.
Assuming they don't do it either, that's.
All right, how about that?
Your Honor, I certainly intend to argue reasonableness, but not a, trying to think, is that the golden rule argument? But we don't intend to say, think about how you would feel if you were walking around, you could stop if you were running, or think about if you were Michael Slager and you were chasing this guy. We're not going to do that, but we certainly need to get into the issue of reasonableness and what's reasonable. And that's precisely their charge to figure out what's reasonable. That can be done without a put yourself in their shoes type argument.
Then we don't have a problem.
All right, well, if we have no problem, then we have no problem. Very good. We're only dealing with problems right now. All right, what's next?
We don't have anything else, Your Honor.
All right, by the state.
I don't believe we have anything else, Your Honor.
All right, regarding exhibits, are you all clear on what's in and what's not?
I believe we are. Is that all, Your Honor?
Yes. All right, we'll be in recess. And what time do you all want to do closing arguments? Well,
11:30?
pardon me?
11:30?
All right, it's 10 o'clock, 11:30. All right. Mr. Savage, how long are you going to argue? I assume you're going to take the final argument for the defense. Yes, sir.
I'm not very good at time.
Like 1 hour, 2 hours, 3 hours?
40 to 50 minutes, probably.
Okay.
I hate to say that.
Well, as I said yesterday, I don't restrict arguments. I know it's an important matter for everyone, and your role is to deal with the jury, and I don't place limitations on time unless there's some stipulation as to that by the parties. I've
He
been in.
gets 15 minutes, I get an hour and a half.
If there's a stipulation. Hey, I've been
I
in.
appreciate that, Judge.
I've been in a trial where the judge says you have 15 minutes to make your closing arguments, and it's not a good feeling.
I appreciate that. If we were to start at 11:30 and then break after Mr. Savage so that I can get my computer set up, my evidence picked out, that would be,
Yeah.
Why don't we start at 2 or 1:30, so we can go right on through.
regardless, I'm going to need some time to get my computer set up and go through the exhibits that I need, that I don't know if he's going to use or not. There's no sense in me doing that ahead of time when he's.
Yeah, well, there are always going to be breaks, because if you argue for an hour, we'll take a break. There will be breaks, planned and
I don't need a long
unplanned.
break necessarily.
I understand, there'll be planned and unplanned, and delays, and I understand there's. Okay.
Could we start at 1 then?
Well, I want to give you all, I know we've been pressed, we've been trying, you have to shift, you have to get ready for closing arguments. I'm fine if you want to start closing arguments at 1, then you have time to be ready.
That'd be great.
I want everyone at their best. So, 1 o'clock?
Judge, we're getting near the end, and I want to tell you, I appreciate your patience
Thank you.
very much.
Let's do it 10 o'clock. Okay, we're going to do closing arguments at 1.
Thank you, Your Honor.
All right, we'll be in recess till then.